Good afternoon. My name is Stacy Blank. I'm here today on behalf of the appellant, the City of Gainesville, and I'd like to reserve 3 minutes of my time for rebuttal. Thank you.
Okay.
This court should reverse the trial court's final judgment because sovereign immunity bars the judgment entered against the city. Under Florida's statutory waiver of sovereign immunity, the city is not liable in tort for the acts of an employee outside the course and scope of his or her employment. If Stormont, a city utility employee, was acting outside the course and scope
And
of his
the state sovereign immunity waiver does not include dangerous instrumentalities.
That is correct.
Okay.
That is correct. If Stormont was acting outside the course and scope of his employment, then the city is not liable for his negligence, and the sovereign immunity would preclude Mr. Rogers' claims against the city.
Well, this has sounded real familiar to the case back from 2018 so far. And in that case, Judge Thomas might remember it. I wasn't on the panel, but did watch the oral argument. The order on appeal there denied the city's motion for summary judgment on sovereign immunity, and then had some specific findings as a matter of law that the doctrine of sovereign immunity does not bar the instant action as the defendant was in the course and scope of his employment based on the dual purpose doctrine. So aren't we stuck with this panel, stuck with that?
I don't think we are, Your Honor, and the reason for that is we don't know what the basis for the decision was in the prior appeal, and they were mutually exclusive arguments advanced.
And I agree with you in that regard. And in fact, opposing counsel, who wasn't Mr. Lee but a different attorney, specifically said it should be a jury question.
That's right.
However, what was affirmed was this ordered and adjudged with the dual purpose doctrine. So aren't we stuck with the specific language of Judge Kime's order?
So I don't think we're stuck with that unless we're stuck with it because the trial judge reaffirmed that finding again on remand when she would not permit the question to go to the jury of whether or not Mr. Stormont was acting within the course and scope of his employment. And that was really the problem that we had at the trial, is that on remand the case went back and the city of Gainesville said, okay, we lost on on our summary judgment motion. The court very well may have affirmed the decision based on the argument that there were disputed issues of fact. We're now ready to present those fact issues to the jury, and the trial court said, no, you can't do that.
Well, I think I remember there being an issue after the appeal of the summary judgment that the parties went back to the trial judge and requested a final judgment. And we had the phrase from the trial judge as a matter of law with respect to the finding on course and scope. And I assume that was because at the time, obviously, focus would have been on the appellate rules and is this an appealable final order? And because it dealt with sovereign immunity, the issue of matter of law had to be in there. So doesn't that answer the question? I mean, if it's a sovereign immunity issue and the appellate rule requires as a matter of law finding to be either semantically stated or clear, doesn't that answer the question?
I don't think it does, because that question may have been answered in that way had there not been an argument presented to the appellate court saying that the decision can be affirmed, the trial court can be right for a different reason than the one articulated in the order, and she could have been right because there were disputed issues of fact that caused her to deny the city's motion for summary judgment. And so keep in mind that Mr. Rogers never moved for summary judgment, so we weren't in front of the appellate court on cross motions for summary judgment. It was just the city's summary judgment motion. And initially, the trial judge says, I'm going to deny the summary judgment motion because I believe there are disputed issues of fact. For some reason, that remains a mystery to me between the time that she announced that ruling at the conclusion of the summary judgment hearing and when she entered her written order. She then flipped and said, okay, well, I don't think there are disputed issues of fact after all. And in fact, I think the undisputed facts demonstrate that Mr. Rogers was within the course and scope of his employment as a matter of law. But the problem is then when it goes up on appeal and the city starts to challenge this, then Mr. Rogers says, well, now wait a minute, even if the appellate court believes that the trial court erred in the determination of what the law is on the dual purpose exception, the court should still affirm because there are disputed issues of fact. This is a fact question. It's almost always a fact question, and it should go to the jury. And so then when the city got back in front of the trial court to put those questions to the jury, then Mr. Rogers said, no, 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 you can't do that now. You're barred by law of the case, and that's already been decided adverse to you. But that can't be because the appellate court could not have concluded both that the facts were disputed and the facts were undisputed. It had to be one or the other, and neither of those. This only presents in a case where the arguments made to the appellate court are inconsistent and mutually exclusive. Because otherwise, we might be barred by law of the case if an argument could be made that the appellate court considered and rejected both of those. But here, they cannot exist together. One of them had to be accepted and one of them had to be rejected.
Doesn't law of the case, though, just lock in what the trial court has already argued? Not the arguments of the parties in support of what the trial court has decided, but what the trial court decided here was sovereign immunity doesn't bar, and that Stormont was, within the course and scope of his employment. So that's.
So I think if that is true, and we're outside law of the case, and we're just dealing with what the trial court decided, for example, at the trial, that she said, okay, I've already made this determination, then I think, we can put law of the case aside, and we're not precluded by what happened in the first appeal. Instead, she has, doubled down on her ruling, and we can argue about that now and whether that's appropriate or not appropriate for her to refuse to present the question to the jury.
Can I ask you a different question? Judge Roberts mentioned the somewhat unusual procedural posture of the appeal. Is there any reason why we can't dismiss the cross appeal in the earlier case and just proceed on the latter case?
There is not. And in fact, that's the reason I filed the second appeal. I was somewhat concerned that the cross appeal might not survive the dismissal of the main part of the appeal, but they are the same.
Yeah.
There are no different issues.
Turning to your second issue on the apportionment of fault and the error and alleged error in not granting a new trial. The trial judge had made some findings in her order denying that. She said the evidence included Mr. Stormont's testimony that he ran a red light and was responsible, Mr. Blackwell's testimony that he was driving at the same speed as traffic, and Mr. Blackwell's testimony that he wasn't injured, and that he was also not wearing his seatbelt. Why does that then not provide some evidence on the other side then, so that the trial court could appropriately, in her discretion, deny the new trial motion?
So I'll take them in the same order that you identified them. The first is the fact that Mr. Stormont was in part negligent and liable doesn't dispose of the question about whether the jury should have apportioned fault based on the undisputed evidence that Mr. Blackwell and Mr. Rogers were likewise at fault. And so we would not suggest that the jury was wrong in finding Mr. Stormont in part at fault, but that the jury got off the rails when it determined that there would be no apportionment based on, its decision, I guess, to ignore the undisputed evidence that Mr. Rogers was not wearing a seatbelt and that Mr. Blackwell was speeding. Going to the next point, the fact that Mr. Blackwell was not ejected from the truck really doesn't answer the question, and I think misses the point, because he was sitting on the other side of the truck. The passengers on the passenger side of the truck were both ejected and were both very seriously injured. Mr. Blackwell was driving the truck, he was on the other side, and so what happened to him, given the dynamics of the accident and what the testimony was about, the force and effect of the collision, that doesn't speak to the issue. It's not evidence that would dispute the evidence of Mr. Rogers not wearing the seatbelt and Mr. Blackwell speeding.
I'm sorry, go ahead.
So is your argument here a manifest weight of the evidence argument, or is it that the Judge Keim erred in not ordering a curative instruction in the face of the trial counsel on the other side repeatedly disregarding her instructions to not talk about whether wearing a seatbelt was legally required or not?
I think it's both of those. I think that Judge Keim should have given the curative instruction, and the result of failing to do that is that the jury ignored the manifest weight of the evidence. They were confused.
Was there a curative instruction proffered, and does that matter?
So there was an instruction offered in the regular jury instructions and on the common law seatbelt defense, and she refused to give that. There were multiple requests for the curative instruction after the closing argument statement, and I think obviously counsel for the city would have been happy to offer one. There was nothing in writing in the record, indicating that something had been submitted, but of course, she just said, I'm not doing it.
So what happens if we rule against the city of Gainesville in the sovereign immunity argument, but rule for you on this issue, that the jurors were confused by the repeated bringing up of this? The counsel said, if you don't find that he violated the law, he conflated a legal requirement with negligence. So let's say we rule in your favor with that. What happens when it goes down below?
So I think it depends on
we have an all-new trial, right?
Well, you have a new trial, but probably it would be subject to the same limitations as the last trial, and that is that we could not put on evidence about whether or not Stormont was in the course and scope of his employment. If your decision is that that issue was one that was precluded to us either by the prior appeal or by the court's ruling at the trial, and we can't.
But theoretically, Mr. Rogers could get a larger verdict, or a verdict that was, even outside, even if it may not be, it may be small enough where it wasn't subject to remediature, but larger than what was initially, that was finally done, right?
That is correct.
So I understand your position is that if there's a new trial, it's a whole new trial, not just a trial on liability.
That's correct.
Okay.
The same in my rebuttal time. I'll
Sure,
reserve
absolutely.
the rest.
Thank you.
May it please the court. My name is Brian Lee. I am representing Jacob Rogers in this case, and wanted to go through the arguments that we have in much the same way as the appellant did. As far as the summary judgment that was entered, I think Judge Bilbrey hit the point that I was going to hit, which is that this court affirmed the trial court's order. The trial court's order stated very clearly that the sovereign immunity did not apply because Mr. Stormont was within the course and scope of his employment. There certainly were alternating arguments that occurred in that appeal, the former appeal, as with most appeals, I'm sure, in front of this court.
So the case before us, it was a written opinion. It wasn't a PCA.
No, it was a PCA opinion. It was a per curiam affirmed.
Okay, then, how can that be law of the case? I mean, there are lots of reasons that appellate courts affirm, and you don't know which ones they clinched upon.
Well, because it was a per curiam affirmed, what this court would have had to say is that they are affirming the trial court's ruling, right? And the trial court's ruling was specific that there were no undisputed facts, and that as to the sovereign immunity issue, and that there was no sovereign immunity, and that he was within the course and scope of his employment. That's what the trial court said. For this court to affirm that, even per curiam, that means that they were affirming that ruling. And so we don't have this argument of what was said within the appeal, because we know what this court said. This court affirmed that ruling. And so, I'm sorry, go ahead.
There was a lot of things, though, that were said in that appeal by Mr. Rogers' counsel, saying that it was a disputed issue of fact. That was said at the summary judgment hearing, in the memo in opposition to the city's motion for summary judgment. I got at least 3 times during the OA where your co-counsel said that it was an issue of fact. So if we PCA'd it because some or all of the panel thought it was an issue of fact, and now you're changing position later on. That just seems, somewhat inequitable at the least.
But that wouldn't be, this court, and this is in my view, this court could not per curiam affirm if it was also finding there were disputed issues of fact, because of the fact that the trial court said there were none. And so the trial court said there were no undisputed facts as to the immunity issue. Went on to say, because there's no undisputed facts, the court finds that he's within the course scope of employment because of the dual purpose exception. By affirming that, this court could not affirm that by saying that there were disputed issues of fact. If this court were to have determined, and of course I wasn't there, Judge Thomas was, but if this court were to have determined, well, you know what, we actually think that there's disputed issues of fact, and that wouldn't have been an affirmance. That would have had to have been an opinion that said, you know what, trial court, we disagree with you, and we think that there's disputed issues of fact, and therefore that goes to the jury. That would have been the only way that would have happened. With an affirmance, we know that's not what happened.
Is there anything in the record as to how this summary judgment came to pass after Judge Keim at the hearing says it's an issue of fact, your co-counsel says, I'll prepare the order, and then we get this order saying, well, as a matter of law, we win, at least on that issue?
There isn't. I'm not aware of any kind of email, letter, anything from Judge Keim that said, by the way, this is what the order is going to be. I believe that there were proposed orders that were sent to her, and then for what reason, we don't know. Judge Keim never told us particularly, or at least I'm not aware of anything, that said that she found that. Now, obviously a trial court does have the ability to do that. Even after saying something in a hearing, it's obvious through the order, because she put it in the order, that she went back and looked at all the materials and went back and looked at the facts that were put forward, and she made her ruling then. And so there isn't any law that I'm aware of that says that what a judge says at a hearing is binding upon what they do in the order. Obviously, the order becomes the order of the court, and that's what this court had.
Say that law of the case isn't an issue and we're just dealing with the course and scope issue then, and we're looking at it fresh. So Stormont had completed his work at the substation and was driving home but wasn't on his regular route yet. He was just about to be on his regular route home, apparently, when the crash occurred. So tell me, is that course and scope, is that coming and going, special errand? What's the theory that your client prevails on that?
Sure. It's a dual purpose doctrine. And so what the dual purpose doctrine says, that if you are in an activity as an employee of an employer, and that your purposes in that activity is not just employee only or personal only, but it's a mixture of the two, then that will still cause you to be an employee for the purposes of you're within the course and scope of employment. It comes from, obviously, the workers' compensation law, which I'm sure this court's very aware. And so when we're looking at it, and I noted cases in my brief, two of which was Hawkins and Hopkins from this case, which are facts that are very similar. And it's even where an employee has finished the work, but is still within that sort of transit from getting from, okay, well, here's the errand I was doing, now I'm getting back to where now I'm going on a personal errand, or even coming into work. This court has said pretty uniformly that that is a dual purpose doctrine. And because of that, they are still within the course and scope of employment. There's obviously a lot of facts that we put in our brief that shows that even though the city is saying, well, he wasn't our employee during that time, he really was. Because there's a lot of things that happened afterwards that show that employee relationship, and that they thought at least this particular crash was part of that employment. And then there's also deposition testimony, of course, from him as well as his supervisors that said that he regularly did this. This was part of his job. And so,
I mean, does dual purpose is it necessarily the only theory that encompasses our evaluation? I mean, to me, dual purpose versus, say, deviation consideration. So as Judge Bilbrey pointed out, if he had yet to get back on his normal route, he was still in the route caused by the allegedly employment-related substation check, the deviation for employment purposes would still continue, period. Is that the analysis? It doesn't necessarily include an analysis of dual-purpose doctrine.
No, and I agree. There are certainly other things that would still put him within the course and scope of his employment. The reason we used dual purpose was obviously that was what was brought before the court before. But there are certainly other ways that this court, even if the court didn't believe, well, we don't believe dual purpose specifically, there are other methods that, from the facts of this case, that would have put him squarely within employment.
Would you concede that had he gotten back on his direct route, had, arguably completed any deviation to check the substation, had he been a bit down the road back on his direct route home, that this would have been, may have fallen another way, not within the course and scope?
It certainly would. It certainly could have, because of the fact that there is this sort of vein through the law of, how much is a deviation, right? When are you back within? I still think the dual purpose would have still applied in that situation, because dual purpose doesn't have that sort of temporal component to it. It says that even if your employer or something you're doing as part of your job, you go do it, the time that it sort of takes you back, even if you're going home, some of the cases talk about it.
Well, that's if you've got some work-related item in the back seat.
Sure.
Here, potentially, advertisement for your employer on the door.
Right, and of course, yeah, obviously he was using a city truck. It was issued to him. He'd been used for 10 years. So there's a lot of facts that even in that scenario, we still think could have led the judge to doing exactly what she did. Could it have gone the other way? Certainly it could. But the trial court said what she said, and so that's where we were.
Let me direct your attention to or did you have a question on this?
No, none of that. Go ahead.
Let me direct your attention to the comparative fault argument.
Sure.
Judge Keim told trial counsel to not talk about whether wearing a seatbelt was legal or not legal because of the danger, and I think rightly so, the danger it could confuse the jury, and that trial counsel several times basically said you've got to, in a nutshell said, if you determine that he didn't violate the law with a seatbelt, he wasn't negligence, and the jury, based on their questions, indicated that they were very confused, and they tried to get more information on what the word legal means in the jury form, where it said the legal cause of the injuries, and they didn't get an answer, and I find it, and Dr. Rash testified, it was unrebutted that Mr. Rogers would not have been ejected from the vehicle and would not have sustained at least as severe injuries if he'd have been wearing a seatbelt, and yet the jury awarded 0 on that. So would you address that?
Sure. So let me start with the argument. So obviously, Mr. McLean, trial counsel there, he brought it up in voir dire and was told not to do it any further, right? So he didn't. He brought it in a cross-examination with their expert and was told that. And then so that was the 2 instances. And then before closing statement, there was this colloquy between the parties about what he could say. And the trial court ultimately, and I cited this in my brief at page 20, said, I think it is appropriate for plaintiff's counsel during his argument to reference that the law that I am instructing them on is the law of the case. That is the law that you're to follow, and this is the only law that applies to the case. So I don't find anything inappropriate about that. Now, what Mr. McLean then did in closing, or excuse me, not in closing, in the rebuttal closing, his second closing, said, you've heard what Mr. Rogers said in addition to saying, well, the windshield didn't want to go through the windshield. He also said it's because he knows he's required by law to wear the seatbelt in the front seat. Go read through these instructions. This is the law in the case. And find one thing that he violated by being in the back seat without it. Now, again, that was not, we feel, contemporaneously objected to. It was objected to later. There was a mistrial, that motion that was done. The trial court denied that, and we believe that did comply with what the judge was saying. The jury was going to be given, because part of the jury instructions, if the court remembers, did have state of Florida says, right? There was an excessive speed one. And so there were things that were in the jury instructions about the law, what the law requires. The city's argument throughout the entire case, and we even went through the closing, was that, well, Mr. Rogers was negligent because he didn't wear a seatbelt. And so the trial court was threading that line, as you saw she did. And she said, well, you can't come out and say that it's not, he doesn't have to wear a seatbelt because the law says he doesn't. But she did allow Mr. McLean to say that here's the law in the case, find something in there that says he's negligent. And that's what he did. And so I don't believe that that was improper. The trial court certainly did not. The trial court talked about, was it floating that line? Maybe. But the trial court found that that was not against my instruction to do that.
Wasn't it a clear advertisement by the jury when they sent back the question to find legal for us? I mean, that, to me, was alarm bells to the judge that we've got an issue here, that the jury is thinking, well, if there's no statute that requires wearing a seatbelt in the back seat, we can't find negligence.
And I think what happened is that, and this is borne out by the record, is that the judge had already, because both sides had wanted to have special instructions. The plaintiff wanted to have an instruction that said there wasn't any law that said it. The defendant wanted to have an instruction that said that you can find, if you find that he wasn't in the back of the seatbelt, that's negligence. The trial court didn't want to do any of those things to confuse the jury. And so when she got that question, much like other questions that trial courts give, she referred them back to the jury instructions. Now, we know at the end of the case, when the jury came out and gave their verdict, they were all polled, they said it was a yes. And we know from the questions of the case, see, the city of Gainesville is saying, well, that must have meant liability, right? They say, well, because they didn't find liability for, the driver and Mr. Rogers, well, that means it was something passion, prejudice. But the questions themselves on the verdict form said, was there negligence? I'll take Mr. Rogers. On the part of Mr. Rogers, that was a legal cause of loss, injury, or damage to him.
Well,
so there's two different questions there.
And that goes back to Judge Roberts' question, rather. Maybe he'll give you a little more time to answer it. Sure. But the biomechanics expert says that Mr. Rogers would not have been ejected if he's wearing a seatbelt. There's no contrary expert saying this would have happened. He would have been just as injured, seatbelt, notwithstanding. Similar on the accident reconstruction expert and the speeding. So wasn't the verdict then against the manifest weight of the evidence when no fault was assigned to either Storment or Rogers, contrary to the experts' opinions?
It was not, because of the fact that there was other evidence, other testimony that the jury could have relied on.
So what's the other testimony that he wouldn't have gone through the window, wouldn't have gone out the side if he was wearing a seatbelt?
Oh, there was no testimony about biomechanical weight, if you're talking about that. But there was testimony that the driver was not injured.
Right, he's up front. He's got a steering wheel.
Sure.
He's gripping on.
Sure, but there was also this, and I'm going by my time. Hopefully, I can get time to do it.
You can answer this question.
But there was this theme throughout the trial that Rogers said was that yes, there was speeding. They were speeding by the vehicle. Mr. Rogers was in the back seat as a passenger, rear end passenger, but that was not the cause of either the crash or the injuries. The cause of it was this impact from Storment. And so the jury could have looked at the facts of the case and what happened and say, well, if Mr. Storment wouldn't have ran the stop sign, there would not have been a crash.
Well, that's a different thing. I mean, certainly, based on the facts of this case, Mr. Storment was the only cause of the crash. But the question here is what was the cause of the injuries that Mr. Rogers received and how severe they were, and whether there was some other party that, including him, that might have contributed to the severity of the injuries, not the crash itself.
Sure. And I think the jury could have, because the jury can reject expert testimony. You know, it's expert testimony not in and of itself is something that is sacrosanct. They can reject expert testimony if they believe that the legal cause was stormont. And that's what we believe they did. Now, we don't know exactly what they did because we don't have cameras in the back room, but we do know when they came out and we do know the trial court found that there was evidence to support that award. And that's all we need to have to not have a manifest way of the evidence argument.
If we disagree with you, is it a new trial de novo on everything, or is it trial only on liability?
I think I would have to agree with counsel. It would have to be a trial on everything.
And then one last question on the procedural issue of your appeal that was already dismissed. Do you see any reason why that whole case shouldn't be dismissed then with the cross appeal and we only focus on the 23 case?
Yeah, I would agree.
Okay, thank you.
Thank you.
All right, thank you, Mr. Lee. Ms. Blank, because we gave Mr. Lee a couple extra minutes, I'm going to give you a couple extra minutes. You're not required to use it, but you may if you need to.
Thank you. Has a lawyer ever stood up here and not used it?
We have had lawyers cede back their time, and it's kind of a power move.
One quick thing I wanted to mention just at the beginning. Judge Bilbrey, I didn't answer all of your questions about the other testimony. I think that Mr. Blackwell did not testify that he was not speeding. I think what he said is that he was traveling at the same rate of speed as other traffic on the road. The computer in his truck indicated that he was speeding. So there was undisputed evidence in the form of the computer information that showed that he was traveling 10 miles an hour over the speed limit. So
But speeding does not always equate to negligence, though, right?
It doesn't.
Okay.
It doesn't. But it does indicate that, but for the speeding, he likely could have avoided the crash. He didn't brake. He didn't swerve. And so the expert
But your average
testimony.
state trooper will give you 10.
Right. Oh, I know. But this was not on a highway, so it was, a greater proportion of the speed limit. So going to the last point that my colleague was discussing. So the evidence was also undisputed that the passenger compartment where Mr. Rogers had been riding was intact after the accident. So it's quite clear that but for the ejection, he and the experts, confirmed that he likely would have walked away with just minor scratches because the passenger seat was not compressed, the roof wasn't, crushed.
Or at least not had the catastrophic injuries he
Correct.
received.
That's exactly right. Thank you. Then I want to talk a little bit about the points that were discussed back on the sovereign immunity issue and the argument about the disputed issues of fact. I disagree with my colleague on that because if in fact what the court was doing was considering only the propriety of the court's ruling on the legal issue, they never would have made the argument that fact disputes required an affirmance. In essence, what they were saying is the court could have been right for the wrong reason, and that could have justified the affirmance in the case. And of course, parties make those arguments all the time, and that's exactly what they did here. And they said, even if you reject what the trial court did on the legal issue, you should nonetheless affirm because there were disputed issues of fact that required the court to deny the city's summary judgment. In no way did they say that the argument on the disputed issues of fact would somehow have supported the legal determination by the trial court that there were no disputed issues of fact. And then you see why I argue that those things are mutually exclusive. That's the amount of time. Any questions?
Madam Clerk, could you add 2 minutes on that? Ma'am?
Thank you.
Oh, okay.
Got it.
Please go ahead.
So the other point that I wanted to talk about just a little bit are the other facts that are in the record about the course and scope of Mr. Storman's employment. It's a little bit interesting to look. Yeah, the testimony was he had never checked this substation at night before. And what happened is he left work, he went to the gym, he worked out, and he was driving home, and he glanced down the side street, and it was dark, and he couldn't tell if the gate was open or closed. And so he decided to drive down and check it. He looked, it was fine, he turned around and headed back out. So this was not part of his normal responsibilities. He was not
But he
charged.
regularly checked that gate, and he regularly checked other gates as he was going around the city, either on duty or off duty. Wasn't that the testimony?
Well, I don't think, there was no testimony that part of his job was to ride the fences of the substations and look, or that he did that in the evenings on his way home from work or after his normal work duties. I think what he said is that as he drove home, he would frequently glance down there, but there was no indication that he had ever driven down there or that he did that on any sort of a regular basis. Now, he had the city car, and if he had been called out because there was something wrong with the substation or there was a problem, then he would have taken the car and gone there. But there was no evidence in the record that I saw anywhere that part of his assigned responsibilities were to ride the circuit and check the gates of the substations, and that part of a concurrent purpose of his trip home that night was to accomplish that. This was a decision he made on the fly. And so my question then is, if that is in fact the law, let's say he had left on a Saturday in the city car and said, I'm going to run 10 errands today, and while I'm here, I'm going to look at a substation. Does that mean everything he did on that Saturday was within the course and scope of his employment? That can't be the result.
Well, I'd analogize that to police officer cases where they're always on call. So they could be off duty, riding somewhere for a personal reason and see an issue and stop, and then that all of a sudden they turn into course and scope. So here, was there any testimony whatsoever that he was considered to be on call or as a manager or supervisor, that it was his responsibility if he saw something awry with respect to any of the electrical stations or lines that he would stop?
The testimony on this was very limited. I think it was I'm not sure how you pronounce it, Bo Liu, who was a supervisor, who testified that the substations were within the scope of his responsibilities. But there was no indication that he had responsibility for sort of riding around and making sure that the substations were secured. Now, I think he was on call, and he testified that he had the company car, so if there was an emergency and he got called out, he could respond to it on a timely basis. But that's a different issue. That is, okay, well, if you get a call and it says a substation is down, repairs need to be made, then he would get called out for that. But that's not the same as saying that he had a responsibility for, in the evenings, riding around and just checking on the security of the substation.
And Storman never filed a workers' comp claim.
He did not. He did not.
Okay, well, now you're out of time.
Thank you.
Thank you both for your argument. I promise our goal here was not to sweat you out with the temperature in the courtroom. Y'all have a good day.
All rise.